Well, hi everyone, Shaun Humphries here. Welcome to the presentation, Estate and Will Planning, Part 1. In this particular presentation, we have put it together to provide you with a general overview on the whole topic of estate planning. And then in future videos, we'll drill down to specific areas like just the area of will planning, for an example. So estate planning has a connotation that's much broader than just will planning. So this presentation has been put together to give you some advanced information. It's a good general overview from an educational standpoint, and it also is intended to provide you with some information before getting together for an individual meeting to unpack this very important area in more detail. So let's look at the general objectives of this presentation and the process of estate planning, and then obviously we'll unpack each of these areas in a little more detail. So the first objective is I want to help you understand the key concepts involved in estate and will planning. Secondly, part of the process is to assess your current personal and family circumstances. So we take a look at your current planning, take a look at your goals and objectives, and see if there's any gaps that need to be addressed. Third, we need to confirm and clarify your intentions. This is a really important component. You know, life is very busy, and we get involved in all kinds of activities. And the one area that often gets short shrift is this whole area of estate planning. Quite frankly, we don't often like to think about it, but nonetheless, it's a very important discussion and a very important part of overall wealth planning. We're going to discover and discuss key issues and opportunities. So once we clarify your intentions and then look at your current situation, we'll be able to identify any issues, opportunities, or gaps in your planning that need to be addressed. And then once we identify those things, begin to look at the priorities. So which things should we take a look at first, and begin to build a bit of a priority list on this whole topic. And then finally create an action plan to achieve your objectives. So what we want to do is, again, assess the current situation, confirm intentions, look at opportunities, prioritize, and then help you execute on the plan. So what's my role? Obviously I'm not a lawyer. I don't hold myself out as a lawyer. As a wealth planner, investment advisor, financial planner, I play a very important role in quarterbacking these discussions. What my experience has been with lawyers and the whole area of estate planning is that they get very busy in the day-to-day things that they're involved in, and the role that I play is to sort of lift you out of the day-to-day, to focus on these really important areas, to do a little bit of pre-work, that before you get in front of your lawyer, you've already identified a lot of your priorities and the different planning you should be doing. And it's not just in the area of will planning. It could dovetail into things like your specific tax planning strategies. If you're a business owner, there could be some succession planning areas that need to be discussed and outlined. So it's building that team approach where we quarterback the tax professionals and the legal professionals to help craft a plan and provide that extra perspective and context for those advisors. So our role is not to replace the lawyer or the accountant in their role. Our role is really to enhance that role, to give them that further context. Again, everyone's busy around the table, and so often there's no one sort of picking up the discussion and leading with a planning perspective, and that's really what our role is. So what is estate planning? That's a good summary. Estate planning is the orderly arrangement of your financial affairs today in order to minimize stress and to allow for the cost-efficient transfer of your personal and business assets to your chosen beneficiaries. Now, if you're dead and gone, you're not necessarily going to be worrying about the stress that other people are going to go through, but it is a reality, right? So we go through this process to minimize the stress that people are going to go through. They're already going through a very difficult time when they lose a loved one. We can reduce some of that stress by making sure that this area of our financial planning is well ordered and looked after. When we talk about a cost-efficient transfer, what we're really talking about is sometimes planning is done very last minute. And what we want to do is get very proactive, very intentional, so that if there are opportunities to reduce probate costs or reduce administrative costs, most importantly is a tax planning area. So there may be some very important tax planning opportunities. Even how assets are registered can make for a much more efficient, time-efficient, cost-effective way of transferring assets upon death. So estate planning really is about all those things wrapped together, and our role is to help quarterback that initiative. So when you look at your estate, what is included in your estate? Well, of course, you've got your assets, and then you subtract from that your liabilities. Liabilities would be loans, as an example, debts that might be outstanding. We then can add to that number any life insurance that you have. So if you have any term insurance, and as you get older, any permanent life insurance that you're carrying gets added to your overall estate. If there's taxes owing, that comes off that total value after you add up your net asset value after the loans and add in your insurance. Then tax could be an outstanding liability. And of course, tax can be triggered on registered accounts like RSPs and RIF accounts, as an example. There could be unrealized capital gains on cottage properties or other real estate or investments like stocks. And then there might be some other expenses that have to be incurred. It could be executor fees, it could be trustee fees, other costs that might have to be looked after, tax preparation costs, trust filing costs. And then all that, after all that's done, that sort of equals your estate. Now, we make the comment at the bottom of the slide that assets with a named beneficiary designation do not form part of your estate. And although technically that's correct, for the purposes of this discussion, really everything that's in your estate is everything that's there. So I could have life insurance proceeds, which are talked about in this listing, that if I have a listed beneficiary, that money will pass directly to the listed beneficiary and does not have to be going through the estate, does not have to be subject to probate to be looked after. But for the purposes of the overall estate, let's ignore probate for a minute and what goes into the estate and what stays out of the estate. Your overall estate is just everything. And then the secondary issue is what goes into the estate, what comes out of the estate. And these videos will unpack that in a little more detail. A very important part of the planning process is the preparation of financial statements. So what you have here on the left-hand side is a preparation of a net worth. For many of you, this is something we do quite regularly. As part of the financial planning process, we'll develop a net worth. Net worth is a great document because it summarizes in one snapshot your assets, your liabilities. Any tax costs can be calculated pretty easily. And so the right-hand sheet is an appendix, and that's calculating tax liability. And so from time to time, it's really important to look at the potential tax liabilities, most of which get triggered on the last to die. So if you have a couple situation, if you have a spouse, most taxes can be deferred past your death to your surviving spouse. It's not until your spouse dies that many of the taxes are triggered. But nonetheless, it's a really good idea to do the calculations to get a sense as to potentially what are the tax liabilities attached to the estate, because sometimes there's some proactive strategizing that can go into dealing with that particular issue. So how does overall estate planning differ from will planning? Well, first of all, a will is just one component of your estate plan. So keep in mind that the will only deals with those assets that go through the estate. You could have other assets that don't do that. I already alluded to that. You could have insurance accounts, policies that have direct beneficiary designations that go to the beneficiary. You could have things like RIF accounts, RSP accounts that have direct beneficiary designations. Again, they don't go through the estate. They're not subject to the will. So the will is just one component of the overall estate planning discussion. A will focuses on getting you organized for what happens in the case of death. But in terms of will and estate planning, overall estate planning can involve different strategies being put in place before you're gone, whether it's corporate reorganizations, whether it's putting in place trust arrangements, re-registration of assets, gifting of assets. There's all kinds of strategizing that go on in advance of your death, and that's part of what overall estate planning is about. So estate planning delves deeper into much more complex issues and strategies to reduce taxes while you're still alive through beneficiary designations or family trusts. It also deals with incapacity issues, so you're still living, but if you have a stroke or health difficulties and you can't act on your behalf, powers of attorney are very critical. Things like living wills or healthcare directives are part of that discussion as well. And so the overall estate planning area is critically important because it's one of those discussions that should ideally involve not just you or you and your partner if you have a partner, but also your overall family unit. Talk about what your intentions are and to plan together as a family to make sure there's a smooth transition if something does happen to you. So we're going to talk about some principles. The goal of estate planning is to provide your loved ones with the maximum of support in the event of your death. And so there's proactive planning, and then putting in strategies once you're gone to provide that support. You do that by organizing your affairs to reduce stress on your family and the administrators of your estate. So we already talked about the stress issue, but it's not just your family members. You could have your administrator, your executor, that's really what we're talking about, or trustees, who are now charged with the responsibility of looking after your wishes. And the better planning you do, the easier you make that for them. You don't want to leave them with a fuddle of mess and sloppiness, or a lack of clarity. So estate planning is really a legacy plan, and you want to make sure that those involved after you're gone have clear marching orders, and you've done a good job through your planning. By documenting your plans, you help ensure that assets distributed and final arrangements made are based on your wishes. So again, that's a very important part of this planning, is that with this intentionality, you're going to get very close to what ultimately you want to see happen as a result of the distribution of your assets. And that can only be done through this intentional pre-planning that we walk clients through. And proper planning will minimize taxes, professional fees, and other expenses, and obviously maximize the funds your beneficiaries will receive. So we often don't think about that, but you've spent many years building up financial assets. The last thing you want to see happen, you may not be there to worry about it, but it would be a shame that if you've put so much time in terms of building up and nurturing your wealth, not just for yourself, but for your spouse and then your family, that it gets eroded unnecessarily because either the plan's not kept up to date, maybe your professionals had to do more work than is necessary because of a lack of clarity. Those are unnecessary things to have to go through if you've got a sound plan, but not just a plan, but a plan that's updated to reflect changes to family circumstances or changes to legislation. And what I find sometimes is that people are a little bit cavalier about this area. They don't really dig in regularly in detail the way they should. So we really do encourage clients, every 5 years or so, even if there haven't been changes to your wishes, your family circumstances, just to dust off these documents, go back to your notes, engage in a conversation, a series of questions that we have for clients to get them re-engaged in this discussion to see whether the old goals and priorities are still relevant for today. We want to anticipate and preempt family conflict. It's really about leaving behind stability, not uncertainty. Sometimes in estate planning, some things are just not said because it's uncomfortable. I'll give you a great example. You sometimes see family members having, they have 2 or 3 kids, a couple of kids live in town. They want to list, both of them as executors or co-executors on the estate. But one of the kids maybe is not really interested in the area. Maybe they're very busy. Maybe they're somewhat irresponsible. But mom and dad just think that they want to treat both equal, and that they would be sending off some wrong signals to one of the kids if they don't name both of them as executors. I can tell you that if you don't have ideal relationships in the area of executorship or powers of attorney, it's a really big mistake to have co-executors. At the end of the day, you want to have a contingent executor, and this is my personal opinion, but you want to have a contingent executor if the primary executor is either unwilling or unable for whatever reason to fulfill their responsibilities. But in most circumstances, I think having one person accountable to look after the estate creates more simplicity, less family complexity or uncertainty or family conflict. And you want to get that discussion out in the open in advance of something happened to you, and go through the reasons why and have a family discussion about it. Often it's the things that are not said that can lead to the conflict that families go through. You want to develop a distribution policy that focuses on who and how and when to distribute the wealth. So again, some people just go, listen, I want to keep my estate very simple. Just upon my death or the death of my spouse, things just get distributed equally. But that's rare. We do find that clients will have legacy aspirations for grandchildren, maybe legacy or charity aspirations to foundations or different charities that they've been giving to over the years. Maybe they've helped one child quite a bit over the years, and so to provide equity, they want to have more of their estate going to the kids that did not need help and they want to reduce the estate distribution to a child or children who got more help over the years. So that's a way that they want to provide some equity. We might have a situation where you have a son or a daughter whose family arrangement, their marriage is a little bit on the rocks. You're worried that if you transfer assets upon death to that family unit, and then subsequent to that there's a divorce or separation, you don't want the money you've worked hard to build up being distributed through a divorce settlement to your former son-in-law. And so different ways of distributing wealth is just the reality. So again, you identify who's going to get assets, how they're going to get it. That's what I just talked about. Sometimes it's a direct distribution. Sometimes it'll be a distribution through trust to protect assets. And when, and again, when is very common with minors, where you'll have trust set up. And then as they get older, you'll see distributions of assets from the estate to reflect the fact that maybe they're more mature and can make use of the assets more effectively as they get older. And then we want to provide flexible solutions to proactively deal with what-if scenarios. So things can change. And so when you build your estate plan, yes, you have a vision for what you want to have happen, but we live in a world of change, dynamic change often, and changes to personal circumstances and family circumstances, changes to tax legislation. And so your estate plan needs to contemplate potential changes and, where possible, to build in those contingency plans in the estate planning. So we'll talk a little bit about taxes on death, because that's relevant to this overall discussion. It's a really big part of the planning that we do and the discussions we have with our clients, accountants, and lawyers. So the first thing to keep in mind is that at the time of death, all of your assets are deemed to be sold. So that would include any cottage, recreational property you have, any stocks or bonds or mutual funds you hold outside of your RSP accounts. So any assets where you've paid something for them, now they're a certain value, it's as if on paper they've been sold, and there's a gain on those assets or a loss that has to be realized as at the date of death. There's no estate tax in Canada, so a lot of people think there's estate tax. There isn't. What we have is capital gains tax, and I'll talk about that in a little more detail. So there's no sort of percentage tax that's applied to your overall estate in Canada, but there are taxes that are triggered, and we'll go through those. A final return must be filed, and so what happens if I die in June, then from January to June 1st, let's say, there's a year of death filing. All income paid, it could be pensions, CPP, old age security, investment income like interest, dividends, whatever's been paid through that time period has to be accrued to the date of death. And then, of course, like I said, all assets are deemed to be sold. That has to be included in the year of death tax filing as well. Capital gains are payable on gains from stocks, bonds, real estate, or investments. So I've talked about that. That excludes your principal residence. And so your home is not brought into that equation. Certainly in the province that I'm in, our province, Manitoba, right next to Ontario, there's a lot of cottage property. So a lot of families have cottages with significant capital gains that have to be dealt with in that year of death filing. Or at least deferred to the spouse, and then when the spouse dies, and then the gains have to be dealt with. Farm families will be another example where there could be significant capital gains. So a lot of the planning that goes into the wealth plan is designed to either reduce the tax liability if possible, to defer the tax liabilities for as long as possible, or to provide funding mechanisms to pay for those taxes, so that families aren't scrambling last minute to find a way of keeping the asset in the family. Again, a great example would be cottage property, which has a lot of emotional attachment to it. Families want to keep those assets for legacy purposes for future generations. But there's been situations where families had such a large tax liability attached to the cottage, there wasn't enough money in the estate to pay the taxes, and ultimately the cottage had to be sold to pay the taxes. So again, this is just being proactive, looking ahead, identifying what the tax costs are, and then planning accordingly if that's one of the goals that the family has. Like I said, the tax can be deferred by transferring assets to your spouse. So in a lot of these discussions around capital gains, there is this deferral mechanism to your partner or spouse. So it's not until the death of the last of the couple that a lot of these tax issues really come into the forefront. And then retirement accounts are also taxed unless transferred to a spouse. So I've got, let's say, RSP accounts, registered retirement income funds, LIRA or locked-in retirement accounts, life income funds, prescribed RIFs. These are all accounts that I'm taking income. When I take the income, it's taxable. any assets within those accounts are tax deferred. Any money still in those accounts on death is deemed to be income in the year of death tax filing. If I have a partner, I can make an election to pass all those deferred gains or deferred income to my surviving spouse, and then that spouse will continue to take income. If there's any money in those accounts on my spouse's death, then the tax will be deemed to be realized. So money has to come into the year of death tax filing. So if I have a $100,000 RSP account or RIF account and I have no spouse, then upon death in the year of death tax filing, that $100,000 comes in as income. So there are a lot of strategies that go into income averaging or trying to get that money out of the account. We sometimes have clients where they may not even need money from the RSPs or the RIFs in any major way, but they're taking money along the way to get it out tax effectively because they're concerned that if something happened to both of them, there would be this balloon payment, this large tax bill that would be triggered. So that's an example of some of the planning, proactive planning that you want to be looking at as we go through the whole estate planning discussion. What about probate fees? Well, probate is a court process to determine whether a will is valid or invalid and authorize the executors to handle the estate. Probate fees generally only apply to assets that form part of your estate, and that would be those assets that, I'll give you a couple of practical examples. If I have life insurance with a beneficiary designation to an individual, it'll pass directly to the individual, does not have to go through the estate. So theoretically, it's not part of the probatable value of the estate. If I have an RSP account, again, my spouse is a listed beneficiary. It goes directly to my beneficiary, does not go through the estate, so probate fees do not apply. A lot of work is done by clients to reduce probate fees. Probate costs are not super expensive in the province of Manitoba anyway. It's around $7 per thousand. So if I have $100,000 in my estate, it's about $700. And generally speaking, you have to look at each client situation, specifically to the goals of the client, their circumstances, the family circumstances, to determine whether they should aggressively try to reduce probate fees and pass assets to listed beneficiaries or through joint registration, or whether they should pass assets through the estate. One of the reasons you would have money going through the estate subject to probate fees is because you want the will to give direction to how the money is to be used. I use the example of, again, if I have a son or daughter whose marriage is not doing well and I'm concerned about maybe a potential divorce down the road. Well, the only way that I can protect those assets for my son or daughter is to pass some money through the estate and into a trust for the benefit of that son or daughter. If I just gift the money directly to reduce probate fees, now my son or daughter has the money, and if their marriage then dissolves, my son-in-law or daughter-in-law would have access potentially to those assets in a divorce settlement. So that would be a good example. You could have an example of minors who need to be cared for and looked after. You might have a trust established under the terms of your will. The money goes through the estate, subject to probate, but then goes into the trust for the benefit of the minors. You might have a family member who is a spendthrift, maybe somebody who's disabled. There are lots of examples where having money go through the estate, subject to probate, is still worthwhile if issues of control and ongoing planning that needs to be done are important to you. So like I said, every situation is very specific. Strategies exist to avoid probate fees. Like I've said, there's joint tenancy with right of survivorship. There's beneficiary designations to named individuals and transfers of property to a trust while you're still alive. So there's lots of ways that we can keep money from going through the estate if it's not necessary to have that control that I talked about. In many cases, strategies to avoid probate would not be the overriding factor in your planning. So I've talked about that. So don't, move in the direction of reducing probate at the expense of the planning strategies. So we've seen situations where people have spent a lot of time drafting wills and estate planning, where the will has some very important structures in it to maintain control, legacy planning, protection, and then the individuals forget that planning's in the will, and then years later they're setting up accounts jointly, they have beneficiary designations, having assets going directly to family members. So on their death, their will really is impotent. The will can't really do what the client wanted the will to initially do, because there's no money going through the estate. So this ongoing review and discussion on estate planning is really important to make sure that that kind of scenario doesn't take place. And then finally, assets held outside of Canada create some very specific estate planning. So are there any U.S. estate taxes that need to be funded? Do you have real estate in the U.S. or in other provincial jurisdictions? Those issues can potentially affect your estate plan. So for the purpose of this discussion, I'm not going to go into it in a lot of detail, but that's one of the questions we'll ask, because that might trigger some additional planning that you need to be aware of. So I hope you found part 2 of this discussion on estate and will planning helpful. And if you need more information, don't hesitate to visit our website at www.shaunhumphries.com. And of course, this information is a really important precursor to any one-on-one discussions that we might have around your estate planning. You take care.